You'll have heard the litany, remanded, remanded, remanded. It's a chorus that plays daily in courtrooms across the city. In fact, across the province. It's a painful and public reminder that justice is grinding slowly, often pointlessly, and with little faith that it serves the community, the victims, or the accused. This is James with Net News Ledger, and we're talking about the court system in Ontario. Our local justice system is faltering, not just under the weight of caseloads, but under the gravity of its own inertia. Cases are being remanded over and over and over again. People are being held for years, months in many cases, in the crumbling Thunder Bay District Jail, which isn't safe, while they wait for the proceedings that often lead to little more than more procedural resolutions or plea deals. For many, the process itself has become the punishment. It's a system that doesn't know when to say no. There's increasing questions about why some cases are in court at all. Minor breaches, technical infractions, or charges involving deeply complex mental health and addiction issues are being prosecuted in a criminal form that's not equipped to deliver solutions, only sentences. You'll hear a drug dealer get released on conditions. A drug addict, a person found intoxicated in the city and arrested, they go to court, they plead whatever they plead, not guilty at their first thing. They're released on the condition that they not drink. When we're dealing with an alcoholic, they have to drink. It's a part of the illness until it's treated. Community advocates and legal professionals alike are quietly sounding the alarm. Too many people are caught in a legal system that's treating social crisis with handcuffs and bars. Instead of meaningful diversion, rehabilitation, or public safety outcomes, courtrooms are tied up in legal minutiae that drains resources and defies logic. Legal aid lawyers are at a breaking point. Honestly, Crown attorneys are overwhelmed. And the judges are often left to referee a system that looks more and more like a revolving door. Thunder Bay and Northern Ontario Indigenous communities have been swamped in a sea of deadly fentanyl and other drugs. Yet too often, the accused, mostly those from Southern Ontario, can afford a hotshot Toronto lawyer and they get released on conditions. You can almost hear the echoes of their laughter as Thunder Bay's overwhelmed and revolving court doors close as they leave to go to do more drug dealing. Sentences are failing to reassure. Take the case of Randy Andrews. He's a 25-year-old who pled guilty to manslaughter in June of 2024. It wasn't until December, 6 months later, he was finally sentenced. He received a 6-year sentence. But with his pretrial custody credited at an enhanced rate, he'll serve a little more than just 4 years. 6 years for manslaughter? In Canada, the maximum sentence for manslaughter is life in prison. However, the actual sentences vary all over the place depending on the circumstances of the case. The key sentencing details for manslaughter in Canada, for example, under Sections 236 of the Criminal Code, maximum is life in prison. Minimum, there's no minimum sentence unless a firearm was used in the commission of the offense, or if a restricted or prohibited firearm was used, a 4-year mandatory minimum sentence. On all cases, judges have a very wide discretion in making sentence on a criminal who's been convicted at trial. The intent and level of violence, whether it was criminal negligence or a sudden altercation, the offender's background and criminal history. Was it a guilty plea or cooperation with the court? The victim income statements and the harm caused. While the law prevents these credits, They're based on precedent, and such outcomes have the effect of eroding public confidence. Families of victims are often left asking, what was the point of the trial? And the broader community is left to wonder whether justice is truly being served or merely administered. The trouble with the legal industry, as it's often called by its critics, is that it's running the risk of people mistrusting the system and eventually, and let's be serious, wrongly, some may decide to take matters into their own hands. Thunder Bay's system isn't the only one that's overwhelmed. It's under-resourced and it's deeply entangled in the broader social failings in our community: housing instability, addiction, historical trauma. A disproportionate number of those remanded day after day are Indigenous, many who are navigating a colonial legal system that has never operated in their interest. The jail is packed. The courtrooms are full. And yet, justice seems increasingly absent. This isn't justice, it's triage, one local defense attorney told Net News Ledger on the condition of anonymity. So, where do we go from here? The calls for reform aren't new, but they are becoming more urgent. Thunder Bay needs an expanded bail supervision program to prevent needless pre-trial detention. We need serious, and by that I mean serious, investment in Indigenous-led justice solutions and alternatives and restorative programs. Thunder Bay's Indigenous court needs to be led by Indigenous elders or Indigenous judges, people who will understand the situation firsthand. As much as we'd like to learn it, it's nothing that you can learn unless you've been through it. We need a complete re-examination from the province of Ontario towards which cases truly belong in criminal court. And we need more judges, more legal aid lawyers, and a much faster sentencing process. Without these changes, Thunder Bay risks losing not just the faith of its legal system, but the very idea that justice is possible in the first place. That's my opinion. I'm James Murray. I'm in the Net News Ledger newsroom here in the vault on Red River Road, and your opinion, you're welcome to differ with me. Like what you see? Subscribe, hit the like button, and make sure to get the notifications.